and welcome to Liberty Nation's LNTV. I'm your host, Mark Angelides. With the Supreme Court coming back into session, we're joined by Liberty Nation's Legal Affairs Editor, Mr. Scott D. Cosenza. Welcome, Scott.
Hi, Mark.
Now, I hear it's going to be a pretty big session this time. What are the big cases and issues that the court's going to address this term?
Well, right away we have a case where homosexuals and transgender people are asking the court to include those categories in civil rights protection for employment and other rights. In the United States, the Civil Rights Acts protect against sex-based discrimination, which is to say, you can't say no women apply for this job or no men are allowed in this club. However, that does not cover sex preference or gender preference and sexuality. You are allowed under federal law to discriminate against people who are, for instance, homosexual in hiring, if you so choose. And also with respect to those, many of the initials past the LGBT in terms of the various gender expressions and identity expressions that are out there. So those folks want the Supreme Court to say that the Civil Rights Acts, when they bar sex-based discrimination, are also including those factors as well.
What are your thoughts on this, Scott? Because it obviously the LGBTQ rights thing, it's a big issue now, but it appears, at least on the surface in America, that it's almost this is something that should have been argued for 50 years ago. It doesn't appear that there really is that much discrimination. I mean, as far as I can tell, I mean, it's somewhat embraced by many industries, especially the more public-facing industries like the media. It's something that's almost embraced or lauded. So it seems strange that there's even a need for this. What are your thoughts on that?
Well, certainly conditions are much better today than they were 10, 20, 30, certainly 40 years ago for people who fit these sorts of classifications. What I'm primarily interested in, this idea of reverse engineering, I think, legislation or the justification for legislation to produce an outcome decades or further down the road that may seem laudable, but had nothing to do with that legislation. For instance, in the Obergefell case, the Supreme Court held that gay marriage was part of the Constitution. No new law or amendment needed to be passed to require states to recognize homosexual marriage. Now, I think if the people want those protections enshrined in law, they should pass legislation or an amendment to the Constitution to allow it, rather than try to reverse engineer a previous law and shoehorn it in there. So that's one of the main issues that we're dealing with the court, Mark. There's also an abortion case that they just granted cert on. So they've just agreed to hear this new case, which concerns whether or not a person who is licensed by the state to give an abortion can be required to have admitting privileges at a hospital. And we have many cases that are kind of percolating up in the abortion area, where in conservative legislatures, Mark, they've passed laws that are kind of designed to get Supreme Court review to kind of drive a wedge in the current abortion jurisprudence.
Okay. Which case are you most interested in, Scott?
In the New York State Rifle and Pistol Association case, Mark, New York City has a law that says if you have a gun license there, and it's highly restricted, so to get a license to have a gun in New York, already you've had to pay probably almost $1,000 in fees and maybe even an attorney review for your application to get it. Well, once you actually get it and you have the gun, New York says you're not allowed to take that gun anywhere except for one of the few approved ranges. So, for instance, you may say, well, what would be the purpose to take the gun somewhere else? Well, if you're going to go travel, if you're going to have a vacation home, if you want to go to your brother-in-law's farm and shoot it in Pennsylvania, all sorts of reasons, legal reasons, why a person may wish to travel outside of New York City with their gun. But New York law says that you can't. So this was challenged, and it's so bad, meaning it's seen, Mark, as so blatantly violative of Second Amendment rights that they went right away after the Supreme Court agreed to hear this case, and they changed the law. And it seems like they changed it, Mark, specifically to avoid the Supreme Court being able to rule on it. So that presented...
They wanted to create a case of mootness, so it wouldn't have to face the 9 Supreme Court justices. Is that right?
That is right. And so the Supreme Court has to now wrestle, before they hear that case, if they decide to, is whether or not they're going to allow that basically quick action to divert the case from their jurisdiction, if they're going to basically hear it or not. We still don't know if that law changed. There's right now a flurry of motions before the court, some arguing that the law change makes it moot, as you say, or that the attempt to evade Supreme Court review is inappropriate and the court should go ahead. So I'm focused on looking at that case and the others we discussed.
Yeah, I mean, obviously Scott will be covering many of the important cases for us on libertynation.com, so head over there to read some great analysis and articles on these topics. But Scott, there's something a little bit different in this session, I believe, regarding rules on oral arguments. What is that?
Yes, the court recently updated its handbook, sort of a guide for people who are conducting oral argument before the court, and they've said, Mark, that the justices are going to try to give them the first 2 minutes of their oral argument time without interruption. Typically, what happens is they'll be called before the bar and they'll start their presentation, and within a sentence or two, right away, one of the justices will interrupt with a question, then that starts the sort of panel. The problem with that, of course, is it doesn't give the litigants generally a chance to make their case. So it's an interesting change. We'll see if the justices actually go ahead and honor that promise to leave them be and let them make their initial argument.
I can absolutely see why when somebody's presenting an argument, they start from point A and go to point B and point C. It's very difficult to make your final, the summary point, if you're being interrupted every couple of sentences. But from the justice's point of view, isn't the purpose of being able to ask the questions is to stop people using an appearance as a showboat or a grandstand? Isn't that the reasoning behind it?
Well, I don't think so, Mark, and it's just because it's so very hard to get before the Supreme Court that almost is never done. But there are times when justices use oral argument so let's say hypothetically, I support gun rights and believe that the Second Amendment supports the right to keep and bear arms on an individual basis. So if President Trump in his wisdom elevated me to the Supreme Court, Mark, and there was a litigant before the bench who was not making the best point on a certain Second Amendment issue, I might ask a question not designed to get an illumination, but really to get him back on track with the right point. And on the other side, if there was a litigant before the court who was making a point that I thought was easily countered, then I might ask a question not again designed to illuminate, but to make a point through the question itself to counter that. So oral argument, for those of us who are into it, it can be a real treat. We'll have to see if I'll certainly be listening to see if the justices grant that 2-minute window.
Well, thank you very much, Scott. Much appreciated.
Thank you, Mark.
And thanks to you at home. Remember, session's just started. We're going to have full coverage of the Supreme Court, all the big stuff, all the fun stuff for you over on libertynation.com, where you can check out more articles, more radio, podcasts, and TV. If you enjoy it, head on over. Thanks for watching.